Samantha. Hello, everyone. Good afternoon. I'm Siddhant, and I'll be taking a flash talk on central bank digital currencies and financial inclusion. Some context to start with for those who are unaware, central bank digital currencies or CBDCs, and this is a peer-reviewed definition, are digital fiat currencies that are operated, administered, and are the liability of a country's central bank, in India's case, the RBI. There has been a lot of interest in CBDCs globally, with 100 plus countries last year experimenting with such prototypes. And in fact, in 2021, a Bank of International Settlements survey found 86% central banks actively researching the potential for these technologies, with over 14% of them deploying such pilot projects. This increasing popularity is attributable to a number of factors, very intuitive actually, which range from increasing digitization, a progressive decline in cash demand over the couple of years, developmental challenges exacerbated, of course, by the pandemic, and the pressing need to financialize underbanked, vulnerable, and unbanked populations of society through such last mile solutions. It therefore becomes clear that I'm so sorry, I'm not able to go to the next slide. Just 1 second. It therefore becomes clear that so sorry, I'll start again.
That's okay. You can continue from where you were because
It therefore becomes clear that CBDCs hold significant potential in catalyzing India's and, of course, the world's socioeconomic inclusive development. However, the intersection between CBDCs and their efficacy in achieving financial inclusion remains under-researched. I attempt to address this gap by comprehensively and systematically reviewing existing literature and scholarly work on the benefits of adopting such technologies. And to do this, I conduct a rapid evidence assessment, which is a form of systematic literature review. I really focus on the umbrella question, which is the role CBDCs can play in financial inclusion. Within this, I first look at the benefits of CBDCs, followed by considerations in operationalizing them, and then finally throw some light into the challenges and risks in their wide-scale adoption and deployment. This is just for visibility. For my rapid evidence assessment, I look at two peer-reviewed journals, Scopus journal databases, Scopus and IEEE Explore, looking at everything published from 2016 to 2022 against an exclusion criteria that has been provided over here. This, of course, translates to 5 key search queries and Boolean operated search queries that I apply to my journal databases, through which I get 715 studies, which against the exclusion criteria are filtered down to 18, which provide the final set of evidence. The findings that I discuss after this are representative of these 18 studies only. Firstly, in terms of the benefits these technologies have for financial inclusion, as most CBDC prototypes currently are driven by blockchain architectures, they are immutable, distributed, and decentralized. And in doing so, they reduce transaction costs and increase economies of scale. Secondly, by enabling people to hold digital legal tenders without having bank accounts, they're also seen to further the UN's SDGs on socioeconomic equity. CBDCs are also seen to have cash-like safety and ease in peer-to-peer payments, which might help in addressing trust deficits in digital finance. Fourthly, CBDCs are also seen to mitigate criminal activities like black money, tax evasion, and money laundering. And finally, CBDCs are also seen to be beneficial for the health of a country's monetary policy by creating efficient payment systems, instruments to regulate money supply, and really overall transparency measures for monetary policy. However, it must be mentioned that CBDC benefits are not absolute and definitely pose trade-offs. For example, research by Ozili in 2022 and Kunha in 2021 show that CBDCs that are designed specifically for financial inclusion may be less effective in achieving other goals like efficiency, monetary policy stability, and price stability. Intuitively, the success of CBDC adoption is also very contextual, with success being low if deployed in context with a low aversion to formal finance or with large informal sectors. And finally, CBDCs should not be geared towards replacing cash and should be geared towards complementing cash use. Therefore, it becomes important to look at the operational imperatives in implementing and deploying CBDCs for financial inclusion. I first look at the technical considerations using Kunha et al. 2021's taxonomy, who classifies CBDC and its various types by four parameters, namely nature of verification, application, degree of decentralization, and the extent of intermediation. For financial inclusion, token-based CBDCs that are not linked to an individual's identity are seen to be more conducive for financial inclusion, as they're seen to mirror cash-like flexibility, be more accessible and private, as opposed to their account or identity-based counterparts. Retail CBDCs that facilitate peer-to-peer transactions are seen to increase access to financial services and therefore are more suitable for financial inclusion as compared to wholesale CBDCs that are only used to facilitate interbank transactions. As to the autonomy or degree of decentralization, CBDCs that are administered by a select few parties are more suited for an intervention by central banks, as restricted degree of decentralization in this context allows for risk management, scalability, and efficiency. And finally, in terms of the extent of intermediation for the health of a country's banking infrastructure and monetary policy, CBDCs that are indirect or are administered by banks and not the central bank are seen to aid in financial inclusion by the creation of diverse and accessible products. Therefore, it becomes clear that a fit-for-purpose CBDC for financial inclusion is token-based, retail, permissioned, and indirect. But we must steer clear of technological solutionism. And therefore, it becomes imperative to examine the capacity constraints in the deployment of CBDCs for financial inclusion. My review finds that the success of CBDC interventions would largely depend on the extent of a country's digital access, consumer competence, literacy, and trust, and the state really of a country's pre-existing technological development. CBDC deployment is interestingly seen to have asymmetric effects across beneficiaries when looked through income levels, genders, and age groups, with young females benefiting the most from such an intervention and old males the least. Therefore, it becomes clear that there are two kind of policy mechanisms principally to help address these gaps, which really range from building trust through awareness, sensitization, and literacy programs, and increased impetus on blockchain research and development and fintech innovation. Coming to technological risks, specifically on privacy, security, and online harms, literature that I surveyed indicates an inherent conflict in safeguarding user privacy and fulfilling CBDC objectives. There seems to be a tension between preventing cybercrime and enabling innovation. This is articulated by Renée and Steele in 2021, who articulate four principal privacy risks, namely loss of anonymity, personal liberty, individual control, and increasing regulatory control. But this is not to say that the absolute flip side, that is absolute anonymity, is useful, as it may increase risks of financial crimes, namely through money laundering, terrorist financing, tax evasion, and proliferate the operation of bad actors. Permissionless cryptocurrencies, such as Ethereum, etc., have also been widely used in the past to enable dark and illicit market transactions. And it also must be noted that there are immense benefits from collecting CBDC data for public good, as it can help identify implementational blockers, produce insights on enhancing system efficiency, and really make the process a lot more seamless. And therefore, discussions must focus on creating a fit-for-purpose central bank digital currency that enable a balance between achieving said policy objectives and safeguarding individual rights. This can be done by a number of mechanisms, some of them being by developing privacy-preserving CBDCs that comply with norms and standards on anti-money laundering and CFT. Secondly, by incorporating privacy by design and privacy enhancing technologies through techniques such as data obfuscation, differential privacy, federated learning into current CBDC prototypes. Thirdly, in order to ensure resilience of CBDC infrastructures, interventions such as hybrid encryption, compliance with best practice standards on security, as well as periodic audits might be useful. The identity issues I discussed earlier could also be addressed by performing KYC checks, though there lacks research on this area currently. And finally, on the issue of over-regulation, regulation by design mechanisms wherein regulatory considerations are embedded into the development and design process might be useful. And finally, it is very important for policymakers, civil society, and industry practitioners to look at privacy and security considerations not as trade-offs, but as losses, as these are non-bargainable. And therefore, to conclude, CBDCs are integral for a country's socioeconomic development, as we've seen. CBDCs should not be geared towards replacing cash, but should in fact coexist with the same to provide options for all beneficiaries. We also saw that token-based, permissioned, indirect, and retail CBDC variants would be most suitable for enabling financial inclusion and access. However, technological solutionism is not the sole way forward, and we should be sensitive to the capacity considerations of a region or a country. In doing so, we have to balance individual rights and prevent harm, at the same time enable innovation. And therefore, fit for purpose CBDCs and future prototypes of the same will be gauged by the extent of their inclusion, accessibility, privacy, security, anonymity, convenience, and user friendliness. That's it from me, and these are the references if anyone's interested. And we do have 3
There was a
minutes.
question for you, as in with CBDC's gradual adoption, the pressure on banks will increase and could lead to a knock-on effect for businesses and households, as the banks may not be able to make loans. How do we overcome this challenge?
That's a very good question and something that current evidence does not really address. I think to what I discussed earlier about the type of CBDC, indirect CBDCs that allow for banks to really operate and administer legal tenders to end users might be useful in this regard. And I think services can be built on top of that.
Okay, thank you so much, Siddhant, for your presentation and sticking to time. You finished on, well ahead of your time. Anyone else has any quick question for him? We just have another 2 minutes. I guess not, but thank you so much, Siddhant, for your presentation. So I guess the next presenter would be from KU, and we would like to have screen sharing access provided to Prerna. They would be talking about how KU is building safe online space for fostering inclusion and empowering the communities. Prerna, would you try sharing your screen?
Hi, Amrita. I am trying. I don't seem
Okay,
to
just
have.
a moment. Admin, can you just give her the...
Already give a replay to Prerna.
Okay, okay. Try now, Prerna. And you could downgrade Siddhant at this point.
Amrita, I think there's an issue. I'm still not able to, but let me just request Rajneesh maybe to share the screen on his end if he's able to do
Okay,
it.
admin, if you could allow Rajneesh to share his screen, because Prerna...
Or Amrita, I can also share a link here. Anybody, it's a...
Okay, admin, can you share this on the screen, please? She's just shared the presentation link. Can the link which has been shared be shown in the screen, please? Just give us a moment. Sorry for this.
No problem.
Okay, can someone from the admin show the, yes, I think something is, oh, Rajneesh has got access, I guess. Let's see. So just for everyone in the room, Prerna and Rajneesh are from KU and they would be sharing what they have been doing. Just bear with us as Rajneesh tries to share his screen.
Is my screen visible now?
Yeah.
Going to, I think.
Okay. Is there a
Yeah.
yellow and with the KU logo, KU's approach to content mod? Is that visible? I can see it at my end.
Likewise, I can see it as well.
Okay, then you're good to go.
Go ahead, Prerna.
Okay. Hi, namaste everyone, and thank you so much for India IGF for giving us this opportunity. So my name, okay, our chosen theme today is trust, safety, and inclusion on the internet. Just to briefly give you an introduction about us, KU app is an Indian homegrown microblogging platform where users can interact with each other in their regional languages. I say Indian homegrown, but we're now global very recently, so we cater to a lot of countries in the world, and I'll talk about it a little later. My name is Prerna. I am a part of KU's Trust and Safety team, and my role largely includes formulating and overseeing the implementation of our platform policies. My colleague here is Rajneesh Jaswal. He is the General Counsel, Head of Policy, and the Compliance Officer at KU. So one of the biggest challenges today on social media, for social media platforms generally, is how to moderate content. It's a very hotly debated topic world over, especially given everything that's happening with the larger social media platforms today. And I believe no one has the perfect solution, but we're going to take the next few minutes to talk about KU's efforts in content moderation. And of course, any questions, comments, or suggestions in this regard are welcome, and we'll take them at the end of the session. To give you a brief understanding of how KU works, and this is important to understand how we moderate content. KU builds, it's a social media platform, of course, but we build language communities. So, for example, say you're a Hindi speaking user or say a Portuguese speaking user. The content, your feed will largely contain content posted by other speakers in Hindi or Portuguese. So basically, you're mostly engaging with other users in your own languages. So our objective is to facilitate a free exchange of thoughts and opinions, but we expect our users to abide by our community guidelines and the laws of the land. Our community guidelines have been structured with the highest regard for freedom of speech, but at KU, laws of the land are supreme. Now, what we believe we're doing slightly different from what other platforms are doing is we don't have one sort of blanket policy for every country we work in. Obviously, we have our base community guidelines, but over and above that, we believe that the lawmakers in each country are in the best position to understand local culture in the context in which the laws are formed. So we would avoid obviously there's certain, I'll talk about it, but we would avoid placing our policies over and above local laws of each country, because we believe that this would be too authoritarian and we might risk curbing freedom of speech. Generally, now how we broadly moderate content is like this. We have three categories of moderation. First is there is obviously moderating content. So when we find any content on the KU platform, this could be what we call a KU or a reku or a comment or a profile photo or anything that's against our community guidelines, we'll remove that content and inform the user. The idea here is obviously to limit circulation of bad content. The second thing is action on user profiles. So generally, if we find any repeat violators or users who are engaging or posting illegal or really extreme content, we will possibly first remove content individually, but if we find them to continue doing this, we'll take action to reduce this user's visibility to other users on the platform. Now, KU very rarely, the highest sort of action we take on profiles is to block their creation ability. So what this means is that the user will no longer be able to post content, but he will continue to have access to the platform to view what other people are posting. Now, only in very, very serious or exceptional circumstances will a user be removed from the platform entirely. Now, actions that would result in this could be users posting, say, child sexual abuse material, or it could be users that are possibly running some APIs that are meant to interfere with Ku's systems and things like that. So generally on Ku, a user's freedom of speech is only curtailed on the basis of their actions, and that's if at all. In only very, very extreme cases of violations or in cases of government orders will we permanently remove a user from our platform. And as we've spoken about before, users are always notified when any action is taken on their content or their platforms, content or their profiles, and they're always given an ability to appeal this action in case there's an error. And we always get back to them within as early as possible, but usually within 15 days if there is an appeal. Rajneesh, could you move to the next slide, please? Thanks. So how we identify violations of our content moderation, we use a combination of human tools and AI tools. With human tools, obviously every user on the Ku platform is given a button at the top to report any violations they might see of Ku's community guidelines. We have a large number of human moderators who then review each Ku that is reported and take appropriate action according to our policies. Then we also use automated tools. So we have two things here. One is we identify text. We have a huge corpus of words and phrases that are considered sensitive in each language. Obviously, each of us is not a language expert, so we work with government organizations and we work with tools to identify sort of language that's repeatedly used in sort of a sensitive context and things like that. And we use that to help us identify potential violations. And again, we have human moderators who will then look at each of these violations, each of these flagged content, and take action accordingly. We also use certain cloud-based AI models to create visual moderation tools. So this helps us identify pictures and videos which might contain certain violations on the platform. That's on identifying. Rajneesh, could we move on to the next slide, please? Okay, so this is something I don't think any other social media platform in the world has made their policies this transparent. And the reason we do this is because, so what is a violation of Ku's community guidelines? We have a community guidelines which lists 16 categories of content which we don't permit on Ku. And this level 1, level 2, level 3 that we've put out here is in no means to say that certain action is more serious or more critical, or that we'll take action against some content but we won't take action. This level 1, level 2, level 3 simply helps us manage, because of the huge inflow of reports we might get. This helps us manage the way we take action. In that, level 1 is just the most extreme cases and most critical and would generally require very immediate attention. Level 2 is still serious, but maybe the virality is not as big. And the reason I say this is just compare something like terrorism and extremism to say violations of intellectual property. Both are very serious, but we believe that certain content needs to be immediately taken down or looked at immediately, which is why we have 3 levels. All content that violates Ku's community guidelines will still be actioned. This is just an order of priority in terms of time management, in terms of managing virality on the platform. Of course, any lawful orders we get from any governments across the globe, if it's in line, and I say lawful because if it's in line with our country treaties and things like that, more often than not, we will take it down almost immediately or at the earliest possible. Rajneesh, next slide, please. Thanks. So recently, like I mentioned at the beginning, so far we were primarily functioning out of India. And this made things easy for us because we have our intermediary guidelines, we have our government, which is very easily accessible to us. And we were able to know what was illegal in India and what was legal in India and base our policies on that. Recently, we've gone global, and some of the challenges we faced is that there are different countries that identify different things as legal and illegal. A simple example could be something like nudity online. In India, it's not permitted, but there are certain countries in the world that permit, say, pornography, that permit nudity, but to a certain extent with certain restrictions. Like we spoke about in the beginning, Ku doesn't believe in placing itself above the laws of the land. So therefore, we do want to apply a blanket policy because it's illegal in one country, we will make it illegal in all countries. So we've come up with certain sort of tech solutions to help us cater to each user. So their freedom of speech is still protected. I would invite Rajneesh to talk a little bit about how we're adapting to global standards.
Thank you, Prerna. The theme of this section is also about inclusivity, and what you see on the screen, the 4 or 5 sections, helps us bring inclusivity on the platform. As Prerna said earlier, different folks in different countries, different cultures have different levels of tolerance to various kinds of content. What geofencing or not promoting in a certain community or not promoting certain folks in certain countries, what it helps us do is preserve the local communities and allow people from those communities to interact with each other. So content is typically geofenced. It is not shown to another. Extreme content from one culture is not shown to another culture. It may or may not be promoted in another place, and so on and so forth. What this helps us to do is make Koo is a very, very local platform. Our USP is working in local languages and ensuring that people at the local level interact with each other and are able to access the internet. All of these features allow us to make sure that local communities are able to have the best possible internet experience for the kind of content they are engaged with and they are used to. I think that's the last slide.
Thank you so much, Prerna and Rajneesh. So I just wanted to ask the room in case you have any questions for the speakers, as in, you can type it into the chat if you want, if there are any questions. Or in case you think you may have any questions, you can always send it to them and they would be happy to take it up, because they have been doing they have been trying to innovate and address certain gaps which have been identified in various countries and as in most of the countries, and the issues which the law enforcement authorities and even regulators are trying to grapple with. So I guess there's no other question for you both, but thank you so much for participating and sharing, all the things which Koo is actually doing to make the online space more safe, trusted, and so that people can use it more. Not only the regular users, but also people who need to get into the online space. So thanks a lot. Thanks a lot for coming here and participating in this session.
Thank you so much.
Thank you. So yes, so we have the last speaker, the fireside chat speaker, Prashant from SFLC, and he would be speaking on another interesting topic, which is software patents in India. Prashant, over to you. Do you need any screen sharing or something, or is it? I can't hear you, Prashant. No audio. I can see you.
Can you hear me now? Yeah.
Yes.
Yeah, I would like to share my screen.
Okay, admin, can you allow Prashant to share his screen?
Already.
Okay, perfect. I'll just share it. Is my screen visible?
Yes, Prashant.
Okay, thank you. Can you see the second slide now?
Yes, we can see your patent and all the still and all that stuff. We can see that.
Okay. Good afternoon, everyone. So the topic that we'll be discussing is about patenting of software. What does the law in India talk about patenting as far as software is concerned, and why patenting in this specific, I would say this specific vertical could be a problem, considering the experience that companies, especially startups, had in countries like the US and the European Union. So what you have on the screen right now is a typical, let's say, an e-commerce portal, and which all elements are patented and how that creates a problem. Now, when it comes to something like software, the problem is that the boundaries are not very clear. When it comes to patenting of, let's say, pharmaceuticals, when it's a molecule for that matter, it's very clear as to what exactly is patented. It's very clear that this specific molecule is patented, nothing beyond that. But when it comes to something like software and where the technology changes every month, every year, you have so much of change as such. Things change within, let's say, 5 years would be like a light years for as far as software and technology is concerned. So when it comes to patents, we are talking about a 20-year patent protection, and that definitely could be problematic. So, in the study conducted in the US mostly by James Besson and Michael Muir, the direct cost of litigation in the year 2011, when the study was conducted, was to the tune of $29 billion. That's thanks mostly due to something called the non practicing entities, or rather the patent trolls, whose only business is essentially to buy these patents, patents of companies which go bankrupt, which let's say cease to operate, and then these patents are bought, and then these are used to, let's say, start litigations against let's new startups, companies who have or let's say who are even big in some cases. So again, when it comes to uh, let's say open source technologies, uh, what open source developers feel that copyright provides sufficient protection as far as innovators are concerned, and uh, patents can be more of a stumbling block or more of a hindrance rather than something which enables innovations. And even other jurisdictions, even US has changed a lot over the last few years with the new judgments which have come, especially from the Supreme Court of the country. But what we have seen happening in India is a bit of a concern. So, if you look at the statutory provision in India, the Patents Act 1970, that governs this field asset, the uh, things to do with the granting of patents, etc. Now, Section 3 of the Patents Act, which was introduced in the year 2000, it completely excludes mathematical and business methods and computer program per se and algorithms from patent protection. So these are not patentable at all. Mathematical methods are not patentable, algorithms are not patentable, and computer program per se, that means computer program as such, are not patentable. Now, in 2004, an ordinance was introduced to amend this section, and this was bifurcated, this provision as such, stating that a computer program per se, other than its technical application to industry, or if it's in a combination with hardware. And the second part, a mathematical method or a business method. So if it's a mathematical method or a business method, it's completely prohibited. You cannot have a patent. And in the case of computer program, exception was given with respect to technical application to industry or a combination with hardware. Now, this was in force for a period of time, but in 2005, the bill was introduced in Parliament, incorporating this provision also. But subsequently, when the bill was discussed in the Parliament, there was a lot of opposition to this provision, and the old provision, which completely excluded computer programs per se, that was brought back in place. So it is a clear intent of the legislation of the Parliament that patenting should not be allowed as far as software is concerned in India. Now, what has happened is, although this is what the law says, we find that a lot of patents are granted when it comes to software in India. Thanks to often, let's say, intelligent drafting, which can often go, so the kind of the claims are drafted in such a language that it, even a computer program which comes under the definition of computer program per se, which is nothing rather than a usual computer program which works on any computer server, etc., that also gets a patent protection. So that is a problem. And in 2008, a draft patent manual was put up for consultation. And here there was a provision which states any claims directed to technical process that cannot be regarded as related to computer programs. And there were certain provisions which were quite ambiguous. And there's a lot of protest, mostly from the open source, let's say, people who work in the open source stream as such against this. And in 2010, a revised patent manual was introduced, and it specifically had this clause which stated that a computer program which may work on any general purpose computer does not meet the requirement of patentability. So it was very clear. So if it's a computer program which just works on a general purpose machine, that is your computer, a server, etc., that is not patentable at all. But then subsequently this was modified in 2011, and also in the year 2013 there was a draft guideline for computer-related inventions which were released, and this brought in a little bit of confusion as far as how these patent applications have to be treated. So it clearly clarified that business methods, mathematical methods, and algorithms cannot be patented, but there was some confusion with respect to computer program per se, where the question was if there's a technical advancement, then whether a patent could be granted for software. Then in the year 2015, this was subject to a lot of debates and discussions when these guidelines were introduced. There was, for example, even for mathematical methods, it was stated that if there is a technical application for it, then it could be patented. It said business methods are not patentable. But then when it came to computer program, it was stated that if it is in a manner so as to establish industrial applicability and fulfill other criteria of patentability, the patent should not be denied. So this again created further confusions. So there's something which the law says, which says computer program per se cannot be patented, but then the guidelines, which is essentially about how these are put into practice, this is what the guidelines stated. Then there was discussions, a consultation was held by the Controller General of Patents. And in 2016, the new guidelines were introduced, which was very clear. It had something called the three-part test, which said, first, you need to figure out where the contribution lies. So what is new as far as the patent which is claimed, patent applications something called the contribution. So what is it that the new claims made by the person who is applying, the applicant is concerned? You need to figure out that. Where does the contribution lies? And if the contribution lies only in the computer software part, then definitely it cannot be patented. So that was clarity as far as the 2016 guidelines were held. Then there was the new guidelines came in the year 2017. Now let's see what has happened over the years. So this was a study conducted by the Software Finance Law Center, starting from the year 2015 to 2022, and we found that although the Patent Act is very clear as that software patents cannot be granted. Patents cannot be granted for inventions in the area of computer programs per se. But this is what the data says. So all these, the numbers, if you look at it, these are irregular patents granted in violation of Section 3K of the Patents Act. So in 2014, 2015, it was 344 patents. Then it went up to, in 2019-20, to up to 1192 patents per year. So that's how the numbers have been increasing, and there seems to be some correlation between these guidelines which were introduced during those periods. So in 2016 we had a guideline which was very clear. So the patent numbers went down a bit. Then again it changed after 2017. So the numbers have been like going up. But definitely, what we are seeing, the numbers show that this definitely is not in tune with what the legislature wanted, what the parliament wanted, where it was very clear that you cannot have patents when it comes to computer software. It was the discussions in parliament. One of the opposition by the MPs at the point of time was that this would give sometimes monopolies to foreign companies, multinational companies, and the Indian companies will suffer. And if you look at the fourth column, it shows that the number of patents granted to Indian entities are often very less compared to those given to foreign entities. And this could create an issue for startups in India in the years ahead. Yeah, that's my presentation. Thank you.
Oh, thank you, Prashant. You have been well ahead of time. Any questions for Prashant? Anyone? You can put it on the chat in case you cannot speak, or you can, I don't know the raise hand option, whether it will work, but you can definitely put it on the
If I
chat.
have time, I can give an example of maybe
You
a
can,
pattern. Yeah.
please go ahead.
So there was this interesting pattern which was about business process outsourcing. The title itself was interesting. It talked about a knowledge transfer system for transferring knowledge. So it was essentially about how knowledge could be transferred from, let's say, a company which has operations in the US. Maybe you can think of any of the business process outsourcing companies in India. They might have an office in the US. They will be talks with the client, and they will try to understand how their systems work and transfer this knowledge to their Indian entities where the development could happen. This entire model, which was mostly about how you could have various SharePoint templates, etc., this was patented. So that is, and if if they go ahead and try to enforce this, it definitely could be a problem for all the BPOs in India.
Thanks, Prashant. Is there any question? Anyone who wants to ask something? I guess not. I'm not seeing anything in the chat either. So thank you, Prashant. I would say thank you for taking out time on a Saturday evening-ish, going to be evening, to share these interesting things, because this is also an important aspect which many people miss out, that these are important. Thank you so much for being here.
Thanks, Amrita. Pleasure to be.
Admin, over to you. I think the session has ended.